Good morning and namaskar. Mr. T.K. Vishwanathan, Deepak, my friend, for the last 25 plus years, and Vineet, great to see you guys. The subject, as Akriti and our colleague here mentioned, investing in India, policy and law roadmap, legislative reforms to make India a US $5 trillion economy. The views, as I start, I want to say personal. India proudly celebrated its 77th Independence Day on August 15 this year, and this year's theme was Nation First, Always First. It is a humbling moment to think with gratitude, strength, determination, and responsible ambition how we catapult our great nation to greater heights. Today we are all over the moon, ladies and gentlemen, and the sun is not far away, in the words of the Prime Minister this morning. To me, the subject of this session is both inspirational and aspirational. It is inspirational because what we are witnessing in our country is an unprecedented and all-encompassing change of a magnitude that has not been witnessed in the past. It is aspirational because when one witnesses such an inspirational change, the aspirations of the country that is comprised of a large young population goes up manifold. And there is a deep desire in everyone for the country to succeed and find its place at the very top. The next 25 years have been called as the Amrit Kal by the Honorable Prime Minister, signaling the advent of a unique, auspicious period in the history of India for which the foundation has been laid down in the last 10 years. It is going to be India's 2 decades ahead, not just economically, but also in the country playing an increasingly important role in the geopolitical stage and bringing about a new world era. So why there is so much of enthusiasm and optimism insofar as India is concerned, and why should India be preferred country for investment, and what is the policy and legislative framework that is unfolding? Consider this, ladies and gentlemen. India is already the 5th largest economy in the world, surpassing the UK in the recent past. As per IMF's World Economic Outlook, the size of the Indian economy will increase from $3.5 trillion in the current financial year to $5 trillion in 2026-2027. India getting to a 5 trillion economy today looks pretty much certain and on the cards, and the question is how soon? But we have to cast our aspirations far beyond. The Amrit Kal period is the period when the country will realize its full potential, given that the last decade has been very well deployed in building the foundation for the same. As per the recently released EY report titled India at 100, even while maintaining a stable yet modest growth rate of 6% per annum, India would become a US $26 trillion economy by 2047-48, with a per capita income exceeding US $15,000, nearly 6 times of the current value, and India will get classified as a developed nation from the one which is developing and emerging. India is home to 17.5% of world population. Indian economy is driven by consumption, and there is enormous headroom to grow consumption. We have a large millennial population, almost 80% millennials and Gen Z. India has the largest under 30 population in the world. There is a 1 billion working class population. India is evolving. There have been landmark reforms in the areas of taxation in the form of GST and streamlining and reduction of corporate laws, corporate taxes, banking reforms in the form of IBC and asset quality review, impetus on infrastructure where we have witnessed an unprecedented 82% rise in the last 2 years of government capex. The focus on Make in India, Atmanirbhar Bharat, which has been a flagship program around which many of the government schemes are taking shape, like the PLI scheme, the Industrial Corridor Development Program, the PM Gati Shakti, the National Logistics Policy, and the Green Energy Policy. The total number of startups registered with DPIIT are 84,000. Unicorns with the total valuation of $350 billion US, many of them have become decacorns from within these. India is unstoppable. India's digital opportunities an eye-opener for the world. A large telecom subscriber base of 1.2 billion and almost 850 million internet users, fueled by government's focus of building digital platforms, have laid a strong foundation for digital India and a digital economy. India's digital economy grew 15.6%, which was 2.4 times faster than the growth of the Indian economy. Several service delivery platforms like COVIN, Ayushman Bharat, Diksha, Umang, GSTN, GEN, ONDC have either been fully successfully implemented or are in the process. The India Stack pioneered in India is the new global benchmark and is the source of competitive advantage for growing businesses while they navigate some of the complexities of the Indian economy. The uniqueness of the India Stack lies in its scale, its open architecture, facilitating transactions designed to serve very high volumes and at low cost. I now turn to my second part of the subject and offer a few suggestions in the space of legislative and policy reforms that could help propel India become a US $5 trillion economy and the third largest in the next 5 years. Since infrastructure is going to get most of the growth in the next 10 years, I'll start with infrastructure. Land reforms in India are critical. This is a key factor of production and an important building block of the economy. Creation of a land database and its digitization is the key. This is an important land reform that needs to be undertaken in the Indian context that will help both industry and agriculture. As disputes regarding land ownership is a major problem in India, the creation of a consolidated national land digital database would help immensely. If all land records can be documented with each parcel of land correctly mapped with its rightful owner, all these records can then get digitized. This will go a long way in promoting agriculture, industry, and infrastructure creation. The Uniform Land Code is another important reform that the land sector can expect. There is a need for a unified land code that can substitute and or subsume various land laws. At every state and even at the central level, there are various laws and regulations governing land-related matters. There are various statutes, regulations, and notifications which pertain to land acquisition, land usage, development-related statutes, including apartment ownership acts. It is time we think of consolidating these regulations and statutes and draft a uniform code which can act as one-stop solution for majority of land-related transactions and matters. I now shift to labor. Codification of labor laws is a step in the right direction. The process of simplifying and streamlining labor laws has commenced and is at an advanced stage. The need of the hour is to expeditiously introduce the labor codes and the corresponding central and state level regulations that talk to each other. This will usher in a landmark reform in a critical area like labor that can propel the economy, further formalize it and grow the economy. Equally, leveraging technology in the labor sector is important, but be it connecting employment exchanges across the country or complete migration of all licensing and registration processes. This will provide multiple benefits to the sector by providing database that will be required for proper analysis and for better decision making and transparency. All compliances, both central and state, can be made and maintained online and shared with the regulators online. Visits by inspectors to the site can be minimized in order to ensure that there are no defaults of insensitive legislations like PF. An option can be given to corporates to deposit their PF liability annually on a provisional basis at the beginning of the financial year, and an adjustment can be made on a monthly basis. This will cut down on the PF-related litigation which can become sensitive. Redefining workforce to promote inclusion is key. Women constitute 50% of our society, however, their representation in the industry is very low, and boosting women representation, especially in the manufacturing facilities, is important. It is heartening to see that many states have in the recent past issued regulations that permit 3-shift working for women with suitable guardrails. This is consistent with PM's call for women-led development. One of HUL's factories, in probably one of the most backward areas of UP in Bundelkhand, has 40% women engineers, so much so that the local ITI college has increased the number of seats for giving admission to women, given that their employment is almost guaranteed. Industrial and manufacturing sector reforms are critical. We need to identify sectors where India can create manufacturing ecosystems. The PLI scheme announced by the government in 2020 will become a game changer and will boost manufacturing significantly. The government has also decided to extend the scheme to other sectors. The new industrial policy can be a vehicle for the government, which the government can deploy to bring about much needed investments that will work as a stimulator to the industrial growth in the country. Some specific suggestions that I want to place with respect to industrial and manufacturing reforms. All licensing and prior permissions to start commercial manufacturing in any sector should be done away with, except for those sectors where licensing is a prerequisite under the IDNRA Act or under the consolidated FDI policy. Industries like FMCG and which are required to seek multiple approvals at multiple occasions from the local regulators like FDA and drug controllers should be allowed to commence manufacturing after they are compliant with the safety and quality standards. Prior permission delays route to market and makes industry less competitive. This is a model that is followed by Southeast Asia and Europe, and it's worked well. A scheme of self-regulation based on compliances with applicable quality standards should be put in place to ensure that quality and safety of the products is not compromised. It should be ensured that all the industries that are being de-licensed for domestic manufacturing have quality and safety standards that are in place. The licensing regime has to be replaced by a regime of self-regulation and at best a market notification regime where the industry can commence manufacturing after ensuring compliance with the standards. The regulator can provide for a scheme of intimation, which is in the nature of an online declaration, and the regulator can raise concerns if once the product and the service is in the market. I see an important role, an enhanced role for district magistrates in 700 plus districts in our country. For new industry, a major reform under the proposed new industrial policy can be to provide new industrial undertakings with the facility of speedy resolution of issues that come up once they are set up and for a period of 5 years thereafter. This can be done through the office of the DM. The government can strengthen the DMs by co-opting experts from power, infrastructure, taxation, environment streams to make DMs a single point window clearing authority for issues concerning land, power, water, GST and environment. Any new industry that is set up can approach the DM for an issue that it encounters in the first 5 years of its operations concerning the areas that are highlighted above. This takes away the need for the entrepreneur to approach higher bureaucracy or the judiciary to resolve such issues. If the entrepreneur is not satisfied with the solution presented by the DM, there can be one opportunity given to them to escalate the matter to the state industry secretary. And I now shift to legislative reforms. Many sectors suffer from excessive legislation to which industry is subject to, even though a lot of effort has been made in streamlining regulation. A sample exercise done for the sugar industry, that is licensed industry, showed that it requires 117 permissions both from the central and state authorities. There is an urgent need to streamline the legislative framework in the country. Also, the new legislation that is on the anvil should be enacted with care to ensure that we do not end up excessively increasing the compliance and the cost burden. A principle of proportionality can be followed. There are many examples that I can give you, but in the interest of time, I'm skipping those. But what I want to emphasize is that there has to be a proper test, and there are certain principles on which any new legislation should be enacted. And some of these could be need for the legislation from the lens of the person and the industry which will be regulated under the proposed legislation, market conditions, orienting the legislation, impact on society and government's ability to enforce, impact assessment of the proposed legislation and its implementation challenges, possible overlap with any existing legislation if any, and experience gathered therefrom, benchmarking with other countries, and implications of not having a legislation. The government should consider setting up a committee of concerned stakeholders for each regulated industry to review existing legislative framework industry-wise. We should give recommendations to the government on repealing those legislations that have outlived their utility. In a bid to bring about rigor in this area, the committee's approach should be to recommend repeal of at least 3 legislations for any one which is enacted. To usher in a culture of compliance and to encourage companies to comply with the regulations, the compliance obligation has to be proportionate to the degree of compliance achieved. Companies that have a track record of compliance should be left to self-regulate or have less compliance burden so long as they adhere to the safety and quality standards. These companies that still have, those companies that still have a journey to complete on the compliance objectives can be subjected to higher degree of compliance. This will encourage them to catch up with the former. Judicial reforms. There is an urgent need to bring about judicial reforms in the country. As of July 2023, there are over 5.2 lakh crore cases pending across various courts in India, in the Supreme Court, in 25 high courts, and in the subordinate courts. A breakup of the pendency shows 60,62,953 cases in high courts and a staggering 4,41,39,35,357 cases pending in the subordinate courts, as per information available on the National Judicial Data Grid. Details of pendencies in the tribunals are not known, but that will also significantly add to the tally. We need to address the cure and not the symptoms. There is a need for finding an end-to-end solution. The future legislation and government policies must be designed in such a way that legislation is the last option. If the statutes provide mechanisms such as mediation, settlement, compounding, and other means of alternate redressal, fresh litigation can be controlled. While adding to the number of benches in different courts and expeditiously filling up vacancies in courts can help, but will not solve the problem holistically. The mediation bill has been passed by both houses of the parliament in the last session, and it should be resorted to as frequently as possible. A lot of work has happened on the decriminalization of laws. The Jal Vishwas Amendment of Provisions Bill 2022 that was introduced in the Parliament during the recently concluded monsoon session seeks to amend several enactments, 42 to be precise, for decriminalizing and rationalizing minor offences to further enhance trust-based governance for ease of living and doing business. Decriminalization approach must be fast forward. This is something which has to go on a continuing basis. The Centre recently introduced 3 bills on August 11, 2023 to reform the criminal justice system enacted by the British in the colonial India with colonial legacies, aimed to with a view to overhaul the several colonial era criminal laws. The bills have been referred to a parliamentary standing committee and for their examination, and hopefully they will get passed in one of the subsequent sessions of the parliament. It is pertinent to note that the proposed law also seeks to give electronic evidence the same legal standing as legal documents have. There is a need to overhaul the criminal justice system in our country, and these bills are in the right direction. Now, finally, to reforms in the corporate laws. Mergers and acquisitions are an indicator of economic activity in the country. Some suggestions to make M&As more enabling and expeditious are as under. Presently, if two companies want to merge, the law requires them to draw up a scheme of arrangement, go to the NCLT after the board and shareholders approval. Some suggestions in this regard are as under. In the case of merger of unlisted companies, there should be no requirement of getting the scheme sanctioned by both the benches of NCLT. After the shareholders of both the companies have approved the scheme, the sanction of NCLT that has jurisdiction over the merging company, which is going to lose the legal existence, should only be taken instead of sanctions of both the NCLTs. Merger of an unlisted and a listed company. In the case of such a merger, approval or sanction of NCLT which has jurisdiction over the listed company should be taken instead of sanction of both the NCLTs after the shareholders have approved the proposal. In the case of merger of listed companies, sanction of NCLT that has jurisdiction over the listed company that would merge and lose legal existence should be only taken. Similar changes can be made in the process for other forms of restructuring like demerger and hive-offs. The above suggestions will ensure faster clearance of M&A proposals and faster implementation of schemes. Easing the M&A regime will send the right signal to the corporate sector and foreign investors, and importantly give an impetus to the economic activity in the country. Artificial intelligence is one of the biggest technological breakthroughs that the world is witnessing in the 21st century, and it touches every sector of the Indian economy. With increasing digitization and globalization, there are newer areas where AI would be relevant in reshaping economies, in innovation and transformation, in innovative and transformative ways. AI is finding acceptability and in several sectors from retail, finance, manufacturing, IT, healthcare, etc. We should do everything to democratize AI. However, AI's proliferation also warrants thoughtful regulation to address ethical and regulatory concerns. The legal community can play an important role in shaping regulation in the critical areas of technology touching human lives. My final point on reforms is one of converting the role of a sector regulator to that of a sector facilitator. It is important to reconsider the role of various sector regulators established by both central and state governments. Instead of sector regulators playing the role just of a regulator for that sector, it is better to recast and repurpose them and make them sector facilitators. The primary function of the sector facilitator should be working to grow the sector and make it stronger. Equally, the sector facilitator should, as part of the role, regulate where required in a way that it facilitates the sector. And the sectors that come to mind are e-com. It is up and coming sector and it should be treated as a sector and should have a sector facilitator. In conclusion, I would say that India is at the cusp of embracing glory from the commencement of the Amrit Kaal. India in 2047 could easily be a US dollar 25 plus trillion economy and one of the most developed countries in the world. As the Honorable Prime Minister said from the ramparts of Red Fort that on the Independence Day, that we are blessed to have demography, the right demography, the best of democracy and diversity, and we are on a journey to perform, reform and transform. For any country to succeed, women's progress is essential. When women progress, the entire household progresses. The Prime Minister talked about women-led development. We are witnessing the same and likely to see a lot more in this area, which is a sign of progress for the entire country. Today, women are present from ASHA and Anganwadi to the areas of STEM and aviation. The PM rightly said that the Amrit Kaal will set the direction for the next 1,000 years, and this will be a godsend opportunity that beckons our country. We at HUL always believe in two core philosophies, which are what is good for India is good for HUL, and doing well by doing good. We have functioned for the last 90 years of our corporate existence with these two philosophies and have served the Indian consumer consistently and responsibly. The legal fraternity has gathered here as an important role to play in not just addressing the need for legislative reforms, but truly in the spirit of nation first, act not just as lawyers but as citizen lawyers. It is our duty also as citizen lawyers to take the law to every household, every citizen, every student, and to make them aware and not only of their rights, but more importantly of their responsibilities and commitments to our country. Thank you.